be impeded only temporarily and for narrowly circumscribed reasons. For example, the second sentence of Article 60 provides that, and I quote, "The occupying power shall in no way whatsoever divert relief consignments from the purpose for which they are intended, except in case of urgent necessity, in the interest of the population of the occupied territory and with the consent of the protecting power." End of quote. The specific conditions for allowing diversion of relief consignments under Article 60 are cumulative, and such action may be taken only in the interest of the local population. Thus, the Court emphasizes that the diversion of relief must remain exceptional, temporary, and only for the narrowly defined purposes set forth in the Fourth Geneva Convention. Any large-scale diversion of humanitarian aid constitutes a violation of obligations under the Fourth Geneva Convention. Moreover, diversion of aid must never undermine the general obligations of an occupying power to ensure that the population is adequately supplied. The occupying power may never invoke reasons of security to justify the general suspension of all humanitarian activities in occupied territory. The Court observes that the distribution of humanitarian relief in an impartial manner requires considerable planning and coordination. Thus, an occupying power must do more than simply allow the passage of essential items into the occupied territory. It must also use all means at its disposal so that these items are distributed in a regular, fair, and non-discriminatory manner, including by facilitating access to them and refraining from threats or use of violence or lethal force against the civilian population seeking to access such humanitarian relief. Relief schemes must be carried out in a manner that respects the dignity of the local population and that is consistent with the protection of the human rights of that population. The obligations contained in Article 59 of the Fourth Geneva Convention arises only when the whole or part of the population of an occupied territory is inadequately supplied. After examining the evidence, the Court finds that the local population in Gaza Strip has been inadequately supplied within the meaning of Article 59 of the Fourth Geneva Convention. In such a situation, Israel, as an occupying power, is under an obligation to agree to and facilitate relief schemes under that provision. The Court next considers Israel's obligations under Article 59 as they relate to UNRWA. The Court observes that these obligations also apply to relief schemes provided by United Nations entities more broadly. The same is true, in principle, for other humanitarian organizations seeking to provide humanitarian relief in the Gaza Strip. The Court recalls that Israel does not consider UNRWA to be an impartial organization and has argued that, as a result, UNRWA does not come within the purview of Article 59. The Court observes that the qualification of a humanitarian organization as impartial or otherwise must be based on an objective assessment. It cannot depend only on the unilateral claim of the organization in question or on the unilateral perception of the occupying power. The court notes that based on the case file, there is no evidence that UNRWA as an entity breached the principle of impartiality within the meaning of Article 59. In other words, there is no evidence that UNRWA has discriminated with respect to nationality, race, religious belief, class, or political opinion during its distribution of humanitarian aid and provision of services in the occupied Palestinian territory. The court observes that while neutrality is not a separate requirement under Article 59, the two concepts are related, and neutrality plays a role in assessing the impartiality of the activities of humanitarian organizations. Israel alleged that UNRWA has been infiltrated by Hamas and other terrorist organizations, and that UNRWA employees took an active part in carrying out the attacks of 7 October 2023. Israel further alleged a widespread and systemic misuse of UNRWA's assets and facilities by Hamas. According to Israel, its concerns were not adequately addressed by the United Nations. The court considers that the information before it is not sufficient to establish UNRWA's lack of neutrality for the purpose of assessing its impartiality as an organization under Article 59. In particular, the fact that the OIOS investigation in 2024 led to the dismissal of 9 members of UNRWA personnel due to their possible involvement in the 7 October 2023 Hamas-led attacks against Israel is insufficient to support a conclusion that UNRWA as a whole is not a neutral organization. In addition, the court finds that Israel has not substantiated its allegations that a significant part of UNRWA employees are members of Hamas or other terrorist factions. The court notes that an occupying power is in principle free to choose the humanitarian organizations through which it fulfills its obligation to agree to and facilitate humanitarian relief. However, Article 59 limits an occupying power's discretion insofar as it requires that power to allow and facilitate sufficient relief to ensure that the population is adequately supplied. The court recalls that UNRWA has become the lead United Nations agency for relief and assistance to Palestinian refugees in the occupied Palestinian territory and neighboring states, playing a critical role in the Gaza Strip. UNRWA has thus been deeply integrated into the local infrastructure of the occupied Palestinian territory, providing for the most basic needs of the local population, including food, potable water, healthcare, and shelter. The court recalls the scale and urgency of the needs of the population of the Gaza Strip and UNRWA's unique and sustained connection with the population of the occupied Palestinian territory. The court considers that in the current circumstances, it is not possible to replicate the capacity of the United Nations acting through UNRWA to ensure that the population of the Gaza Strip is adequately provided for. UNRWA cannot be replaced on short notice and without a proper transition plan. The court further observes that Israel itself has not ensured that the population of the Gaza Strip is adequately supplied. The court recalls that in addition to severely restricting the entry of aid at various times after 7 October 2023, Israel blocked the delivery of humanitarian aid in the Gaza Strip starting from 2 March 2025 and only allowed the delivery of a limited amount of aid to resume on 19 May 2025. The evidence thus shows that whether or not the operations of the United Nations acting through UNRWA were replaceable, Israel had no replacement system mobilized for a 10-week period. The Gaza Humanitarian Foundation, a purported replacement for UNRWA, has been widely criticized by the United Nations and other international actors, and its operations have been alleged to be inconsistent with core humanitarian principles. The United Nations observed in its response of 27 August 2025 that aid delivery remains significantly below the volume required to meet the needs of the population. According to the Office for the Coordination of Humanitarian Affairs of the United Nations, to which I shall refer as OCHA, over 2,100 Palestinians have been killed at or near the distribution sites of the Gaza Humanitarian Foundation since that system began operating on 27 May 2025. The court concludes that in the present circumstances, the United Nations, acting through UNRWA, has been an indispensable provider of humanitarian relief in the Gaza Strip. Having regard to Article 59 of the Fourth Geneva Convention, and in the circumstances, the court considers that Israel is under an obligation to agree to and facilitate relief schemes provided by the United Nations and its entities, including UNRWA. The court adds that Article 59 of the Fourth Geneva Convention refers to aid provided by states or by impartial humanitarian organizations. Thus, as long as the population remains inadequately supplied and Israel is not itself operating a system of humanitarian support that is in accordance with its obligations under international humanitarian law, Israel is obliged under Article 59 to agree to and facilitate relief schemes provided by third states or impartial humanitarian organizations such as the International Committee of the Red Cross. The court then turns to other obligations under international humanitarian law. As an occupying power, Israel is obliged to ensure the basic needs of the local population, including the supplies essential for their survival. Obligations to this effect are set out in Articles 55 and 56 of the Fourth Geneva Convention, as supplemented by Article 59, Part 1 of Additional Protocol 1. The court observes that Israel's obligations under Articles 55 and 56 are not dependent on the local population being inadequately supplied, and therefore also extend beyond the Gaza Strip to other parts of the occupied Palestinian territory. In the court's view, under these provisions, Israel is not only required to perform the positive obligation to ensure essential supplies to the local population to the fullest extent of the means available to it, but it is also under a negative obligation not to impede the provision of these supplies or the performance of services related to public health. In this respect, to the extent that Israel does not itself fulfill the obligations under Articles 55 and 56, leaving that responsibility to the United Nations, acting through UNRWA, as well as other international organizations and third states, Israel is under the same positive and negative obligations to support and not to restrict the activities of those entities. The operation of the United Nations through UNRWA and those of other international organizations and third states have been central to Israel's performance of its obligations as an occupying power under Articles 55 and 56 of the Fourth Geneva Convention. Consequently, Israel's obligations under these provisions require it either to facilitate those operations or to otherwise ensure that these obligations are fully met. The Court next discusses the obligation of Israel to respect and protect relief and medical personnel and facilities. The Court explains that the principle that humanitarian relief personnel must be respected and protected forms part of customary international law. The activities of the relief personnel may be limited and their movement may be temporarily restricted only in case of imperative military necessity. Personnel participating in relief actions are also protected by the principle of distinction unless and only for such time as they directly participate in hostilities. The obligations of an occupying power exist alongside the obligations under international humanitarian law of all parties to a conflict to protect civilian hospitals and to protect and to respect and protect medical personnel exclusively assigned to medical duties in all circumstances. The Court then observes that the first paragraph of Article 49 of the Fourth Geneva Convention provides that individual or mass forcible transfers and deportations from occupied territory of protected persons within the meaning of that convention are prohibited, regardless of their motive. Deportation or forcible transfer of the civilian population of an occupied territory in whole or in part is also prohibited under customary international law. The Court recalls that transfer may be forcible not only when it is achieved through the use of physical force, but also when the people concerned had no choice but to leave. This may include inflicting conditions of life that are intolerable. While the second paragraph of Article 49 of the Fourth Geneva Convention allows an occupying power to evacuate people to a given area if the security of the population or imperative military reasons so demand, it provides that persons thus evacuated shall be transferred back to their homes as soon as hostilities in the area in question have ceased. The Court observes that the third paragraph of Article 49 further stipulates strict conditions for such evacuations. According to some participants, including the United Nations, the Israeli military has issued numerous displacement orders, forcing hundreds of thousands of people into overcrowded areas and restricting the United Nations' ability to deliver urgently needed essential supplies. The Court observes that Israel, as an occupying power, is prohibited from restricting the presence and activities of the United Nations other international organizations and third states in and in relation to the occupied Palestinian territory to a degree that creates or contributes to conditions of life that would force the population to leave. The Court next recalls the provisions of Articles 76 and 143 of the Fourth Geneva Convention and concludes that Israel is obliged to allow the ICRC access to visit protected persons from the occupied Palestinian territory detained by the Israeli authorities. In its final section on international humanitarian law, the Court explains that custom international law prohibits the use of starvation of the civilian population as a method of warfare. As the Court has noted, Israel blocked aid into the Gaza Strip, preventing the entry of humanitarian aid into the region from 2 March until 18 May 2025. In the view of the Court, Israel's consent to operation of the Gaza Humanitarian Foundation since 27 May 2025 and to other limited humanitarian aid has not significantly alleviated the situation. The Court further refers to its finding that the local population in the Gaza Strip has been inadequately supplied. In these circumstances, the Court recalls Israel's obligation not to use starvation of the civilian population as a method of warfare. As an occupying power, Israel has obligation under international human rights law to respect, protect, and fulfill the human rights of the population of the occupied Palestinian territory. Restrictions on the provision of humanitarian aid that is indispensable for the well-being and dignity of the Palestinian population directly implicate these obligations. Israel is a party to several United Nations human rights treaties. These include the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Cultural, and Social Rights, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the Convention on the Rights of the Child, and the Convention on the Rights of Persons with Disabilities. In the Court's view, the principle that the state's human rights obligations extend to acts taken by that state in the exercise of its jurisdiction outside its own territory, particularly in occupied territories, applies with respect to all these treaties. Both the human rights treaties to which Israel is a party and customary international law encompass a wide range of human rights that are relevant to the population of the occupied Palestinian territory. These rights apply alongside the obligation of an occupying power under international humanitarian law, including the obligation under Article 27 of the Fourth Geneva Convention that protected persons shall be respected and humanely treated, and the specific obligations of an occupying power addressed earlier. Such rights include the right to life, the right to be free from torture or cruel, inhuman, or degrading treatment or punishment, the right to liberty and security, the right to freedom of movement, the right to protection of family life, the right to an adequate standard of living, including adequate food, clothing, and housing, and the continuous improvement of living conditions, the right to the enjoyment of the highest attainable standard of physical and mental health, the right to education, and the right not to be subject to discrimination on specific grounds. The Court has confirmed that Israel has a positive obligation to respect, protect, and fulfill international human rights in the occupied Palestinian territory, even in times of armed conflict. The Court observes that to the extent that the local population has been capable of enjoying many of these human rights in the occupied Palestinian territory, this has been largely enabled and ensured through the work of the United Nations, particularly through UNRWA, supported by the activities of other international organizations and third states. Consequently, any diminution by Israel of the capacity of UNRWA and these other actors to ensure these basic human rights means that the obligations of Israel to respect, protect, and fulfill these rights increases to a commensurate degree. In its advisory opinion, the Court recalls policies and practices of Israel that have resulted in the deprivation of the essentials of daily life for the local population of the Gaza Strip. The Court then discusses how the various rights it has identified may be engaged. The Court next turns to the obligations of Israel as a member of the United Nations. The Court starts by recalling the responsibility of the United Nations toward the question of Palestine, which was described by the General Assembly as a permanent responsibility until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. The Court then discusses the obligation to cooperate with the United Nations. By virtue of Article 2, Paragraph 2 of the Charter, all members must fulfill in good faith the obligations assumed by them in accordance with the Charter. This provision must be applied in conjunction with the specific obligations assumed by the members in accordance with the Charter. In realizing the purposes of the United Nations, as enunciated in Article 1 of the Charter, members have a specific obligation to cooperate with the United Nations under Article 2, Paragraph 5 of the Charter, which provides that all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This provision must be read together with the provision of the Charter relating to the powers of various organs of the United Nations. Compliance with this duty to render assistance is important for the effective functioning of the organization, the fulfillment of its mandate, and the independence and efficacy of its personnel in the discharge of their duties. Furthermore, members are under obligation to cooperate with the United Nations under Articles 55 and 56 of the Charter. The obligation of Israel and of all other member states to cooperate with the United Nations with respect to the question of Palestine is of paramount importance in addressing the critical situation on the ground since October 2023, in which the United Nations, together with other actors, plays a crucial role in delivering and coordinating humanitarian aid and development assistance to the occupied Palestinian territory, in particular through UNRWA in the Gaza Strip. The Court recalls that Israel, as an occupying power, is not entitled to sovereignty over or to exercise sovereignty powers in any part of the occupied Palestinian territory, including East Jerusalem. By enacting and enforcing the two laws adopted by the Knesset on 28 October 2024, that unilaterally terminated Israel's cooperation with UNRWA, including its operation in East Jerusalem, Israel continues to exercise sovereign power in East Jerusalem. Moreover, these laws have directly resulted in obstructions to the operations of UNRWA in and in relation to the occupied Palestinian territory, in particular in the Gaza Strip. Furthermore, the Court notes that UNRWA, as a subsidiary organ of the United Nations, has been entrusted by the General Assembly to provide direct relief and work programs for Palestine refugees. It cannot carry out such a mandate effectively without having direct access to the population in the occupied Palestinian territory. This is particularly true given the crucial role that UNRWA has been playing since October 2023. In the view of the Court, Israel is not entitled to withhold its cooperation with the United Nations by unilaterally deciding on the presence and activities of the United Nations entities in and in relation to the occupied Palestinian territory, subject to paragraph 184 of the advisory opinion. Lastly, Israel must fulfill its obligations in good faith. In the event of any difference arising between Israel and the United Nations, the obligation to cooperate requires Israel to pursue consultation and negotiation with the United Nations. The Court then turns to the obligation to respect the privileges and immunities of the United Nations. It refers first to Article 105 of the Charter of the United Nations. It adds that the privileges and immunities of the United Nations are further set out in the Convention on the Privileges and Immunities of the United Nations, to which I shall refer as the General Convention, adopted by the General Assembly pursuant to Article 105, paragraph 3 of the Charter. Israel acceded to the General Convention on 21 September 1949 without making any declaration or reservation. The Court emphasizes that the privileges and immunities accorded to the United Nations and its personnel are functional in nature. These privileges and immunities are not accorded as benefits to the United Nations or its personnel, but to safeguard their functions. The Court recalls that, as a general rule, the way in which a subsidiary organ established by the General Assembly is utilized depends on the consent of the state or states concerned, and that states possess a sovereign power of decision with respect to their acceptance of the headquarters or regional office of an organization within their territories. It follows that within the territory of Israel, the presence and activities of the United Nations and its entities are subject to the consent of Israel. However, in the occupied territory over which Israel, as an occupying power, enjoys no sovereignty, it is not entitled to decide unilaterally with respect to the presence and activities of the United Nations in and in relation to the occupied Palestinian territory, in the same way as in its own territory. The Court is of the view that in the context of an occupation, an occupying power exercises jurisdiction and control over the occupied territory and thereby assumes an obligation to respect the privileges and immunities accorded to the United Nations under Article 105 of the Charter and the General Convention in the occupied territory. The Court considers that Article 105 of the Charter and the General Convention do not cease to operate in the context of armed conflict. This is consistent with the purposes and functions entrusted to the United Nations, which often carries out important missions in areas of tension and conflict. Pursuant to Article 105 of the Charter and the General Convention, pursuant to Article 105 of the Charter, General Convention sets out the privileges and immunities that the United Nations and its personnel enjoy in the overall performance of their functions. For the purposes of the present proceedings, the Court considers the following aspects and the corresponding provisions of the General Convention to be of particular relevance to the question put to it. First, the obligation to respect the privileges and immunities accorded to the United Nations, its premises, property, and assets. Second, the obligation to respect the privileges and immunities of United Nations personnel. And third, the obligation to address any concern regarding the privileges and immunities of the United Nations and its personnel within the legal framework of the United Nations. The Court then discusses these obligations in detail in the context of the occupied Palestinian territory. Concerning the obligation to respect the privileges and immunities accorded to the United Nations, its premises, property, and assets, Israel must respect the immunity from the legal process of the United Nations, its property and assets in and in relation to the occupied Palestinian territory. Furthermore, Israel must respect the inviolability of the premises of the United Nations, including its field offices in the occupied Palestinian territory, and not interfere with the performance of their functions. The Court considers that the question whether a particular facility in the occupied Palestinian territory qualifies as the premises of the United Nations must be assessed by taking into account the specific circumstances pertaining to each facility concerned. With respect to the question whether the schools, health clinics, and the hospital operated by UNRWA in the occupied Palestinian territory fall within the category of United Nations premises, the Court is of the view that what is pertinent is whether the function and services provided by these facilities form part of the mandate of UNRWA. If that is the case, in addition to its obligations under international humanitarian law, Israel is under an obligation to respect the inviolability of these premises in accordance with Article 2, Section 3 of the General Convention. The obligation to respect the inviolability of the United Nations premises and the obligation not to interfere with the United Nations property and assets must also be upheld in the context of armed conflict, as such inviolability and non-interference are essential to safeguarding the independent and effective performance of the functions of the organization under all circumstances. The Court acknowledges that the context of an armed conflict raises challenges, especially in the situation of potential loss of control by the United Nations over certain of its premises. However, it is for the United Nations to determine whether a particular facility remains the premises of the United Nations. In the view of the Court, such a determination by the United Nations of the present advisory opinion, the term United Nations personnel refers to its officials as well as its experts on mission. In and in relation to occupied Palestinian territory, Israel must respect the independence of United Nations personnel and the privileges and immunities necessary for the exercise of their functions. The Court considers that United Nations personnel are entitled to the privileges and immunities provided by Article 105 of the Charter and Articles 5 to 7 of the General Convention for all acts performed by them in their official capacity. It is for the Secretary General to determine whether a particular official or expert on mission is entitled to the privileges and immunities provided, and to assess whether that person acted within the scope of the person's functions. In the view of the Court, the Secretary General's determination of the scope of the official functions of the officials or experts in question creates a presumption that can only be set aside for the most compelling reasons and is to be given the greatest weight by states. In light of the foregoing, Israel is prohibited from taking actions contrary to its obligations under Articles 5 and 6 of the General Convention against United Nations officials and experts on missions operating in and in relation to the occupied Palestinian territory. In addition, Israel has obligations under the General Convention with respect to the free movement of United Nations personnel in and in relation to the occupied Palestinian territory so that they can carry out their mandated activities. The Court notes that in the context of the occupied Palestinian territory, the United Nations and its entities operating on the ground rely extensively on the contribution of local personnel. In this regard, the Court emphasizes that the free movement of local United Nations personnel for the performance of their official functions must also be respected by Israel. In concluding its analysis of the privileges and immunities of the United Nations, the Court notes that the United Nations has a responsibility to prevent and address abuses of the privileges and immunities of the organization and its personnel. The legal framework governing the privileges and immunities of the United Nations is not impervious to the legitimate concerns of members over such abuses. The privileges and immunities accorded to the United Nations and its personnel cannot be used as a shield for activities that are against the purposes and principles of the organization or are outside the functions of its personnel. Nonetheless, any concern of alleged abuse raised by a member regarding the United Nations or its personnel must be addressed within the existing legal framework for the settlement of differences. In any event, a member must not disregard its obligations under the Charter based solely on its unilateral assessment of the allegation. On the basis of the material before it, the Court notes that in response to the allegations concerning actions by UNRWA personnel, the United Nations took immediate action, launching 2 separate investigations, an internal one conducted by OIOS and an external one led by a group of independent experts. In the present context, it is important to reaffirm that a member has no right unilaterally to revoke the privileges and immunities accorded to the United Nations and its personnel, nor to abstain from performing the obligation that it has assumed. In the last section of its advisory opinion, the Court discusses the presence and activities of the United Nations in support of the right of the Palestinian people to self-determination. The Court is mindful that the present request for an advisory opinion has not arisen in isolation, but is situated in the context of Israel's prolonged occupation of the occupied Palestinian territory for more than 58 years, and the continued denial of the Palestinian people's right to self-determination. The Court recalls that Israel's territorial claim over East Jerusalem has long been declared null and void by Security Council Resolution 478, 1980 of 20 August 1980. The Court notes that the law to cease UNRWA operations in the territory of the State of Israel purports to apply to East Jerusalem. As an occupying power, Israel must refrain from extending its domestic laws to the occupied territory in any manner inconsistent with its obligation not to impede the Palestinian people from exercising its right to self-determination, including its inalienable right to territorial integrity over the entirety of the occupied Palestinian territory. Moreover, the humanitarian crisis in the Gaza Strip poses a direct risk to the living condition of the Palestinian people. The deprivation of the people of its essential means of subsistence threaten the fundamental conditions that are indispensable for the people to exercise its right to self-determination. Respect for the right to self-determination of the Palestinian people requires Israel not to prevent the fulfillment of the basic needs of the Palestinian people in the Gaza Strip, including by the United Nations, its entities, other international organizations, and third states. Lastly, UNRWA's unique mandate relates to the core aspect of the right of the Palestinian people to self-determination. The missions undertaken by UNRWA in the areas of direct relief, humanitarian and development assistance, through its programs covering education and training, healthcare, direct relief, and development services, are a manifestation of the organization's commitment to its responsibility with respect to the right of the Palestinian people to self-determination. Moreover, as noted earlier, since October 2023, UNRWA has remained the principal means and the backbone of all humanitarian response in the Gaza Strip, serving Palestinian refugees and civilians in urgent need of life-saving humanitarian assistance. In this connection, Israel is under an obligation not to impede the operation of the United Nations entities, other international organizations, and third states, and to cooperate in good faith with the United Nations to ensure respect for the right of the Palestinian people to self-determination. The Court reiterates that ultimately, the realization of the right of the Palestinian people to self-determination, including its right to an independent and sovereign state, living side by side in peace with the State of Israel, within secure and recognized borders for both states, as envisaged in resolution of the Security Council and General Assembly, would contribute to regional stability and the security of all states in the Middle East. For these reasons, the Court unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, is of the opinion that the State of Israel, as an occupying power, is required to fulfill its obligations under international humanitarian law. These obligations include the following. A, unanimously, to ensure that the population of the occupied Palestinian territory has the essential supplies of daily life, including food, water, clothing, bedding, shelter, fuel, medical supplies, and services. B, by 10 votes to 1, to agree to and facilitate by all means at its disposal relief schemes on behalf of the population of the occupied Palestinian territory, so long as that population is inadequately supplied, as has been the case in the Gaza Strip, including relief provided by the United Nations and its entities, in particular, the United Nations Relief and Works Agency for Palestine refugees in the Near East, other international organizations and third states, and not to impede such relief. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. C, unanimously, to respect and protect all relief and medical personnel and facilities. D, unanimously, to respect the prohibition on forcible transfer and deportation in the occupied Palestinian territory. E, unanimously, to respect the right of protected persons from the occupied Palestinian territory who are detained by the State of Israel to be visited by the International Committee of the Red Cross. And F, unanimously, to respect the prohibition on the use of starvation of civilians as a method of warfare. 4, by 10 votes to 1, is of the opinion that, as an occupying power, the State of Israel has an obligation under international human rights law to respect, protect, and fulfill the human rights of the population of the occupied Palestinian territory, including through the presence and activities of the United Nations, other international organizations, and third states in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. 5, by 10 votes to 1, is of the opinion that the State of Israel has an obligation to cooperate in good faith with the United Nations by providing every assistance in any action it takes in accordance with the Charter of the United Nations, including the United Nations Relief and Works Agency for Palestine refugees in the Near East, in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. 6, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Article 105 of the Charter of the United Nations to ensure full respect for the privileges and immunities accorded to the United Nations, including its agencies and bodies, and its officials, in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. 7, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Article 2 of the Convention on the Privileges and Immunities of the United Nations to ensure full respect for the inviolability of the premises of the United Nations, including those of the United Nations Relief and Works Agency for Palestine refugees in the Near East, and for the immunity of the property and assets of the organization from any form of interference. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. 8, by 10 votes to 1, is of the opinion that the State of Israel has an obligation under Articles 5, 6, 7 of the Convention on the Privileges and Immunities of the United Nations to ensure full respect for the privileges and immunities accorded to the officials and experts on mission of the United Nations in and in relation to the occupied Palestinian territory. In favor, President Iwasawa, Judges Tomka, Abraham, Shue, Nolte, Charlesworth, Brandt, Gomez-Robledo, Cleveland, Tladi. Against, Vice President Sebutinde. I shall now call upon the registrar to read the operative part of the opinion in French.
Ces motifs, la Cour, 1, à l'unanimité, dit qu'elle a compétence pour donner l'avis consultatif demandé. 2, à l'unanimité, décide de donner suite à la demande d'avis consultatif. 3, est d'avis que l'État d'Israël, en tant que puissance occupante, doit s'acquitter des obligations qui lui incombent en vertu du droit international humanitaire. Ces obligations sont notamment les suivantes. A, à l'unanimité, faire en sorte que la population du territoire palestinien occupé dispose des produits essentiels à la vie quotidienne, notamment l'eau, la nourriture, les vêtements, le matériel de couchage, les abris et le combustible, ainsi que des articles et services médicaux. B, par 10 voix contre 1. Accepter et faciliter dans toute la mesure de ses moyens les actions de secours faites en faveur de la population du territoire palestinien occupé, tant que cette population est insuffisamment approvisionnée, comme cela a été observé dans la bande de Gaza, y compris les actions de secours menées par l'Organisation des Nations Unies et ses entités, en particulier l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, et par des organisations internationales et des États tiers, et ne pas empêcher de telles actions. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Shue, M. Nolte, Mme Charlesworth, M. Brandt, Gomez-Robledo, Mme Cleveland, M. Tladi, juge, contre Mme Sebutinde, vice-présidente. C, à l'unanimité, respecter et protéger tout le personnel de secours et le personnel médical ainsi que leurs locaux. D, à l'unanimité, respecter l'interdiction du transfert forcé et de la déportation dans le territoire palestinien occupé. E, à l'unanimité, respecter le droit des personnes protégées du territoire palestinien occupé qui sont détenues par l'État d'Israël de recevoir la visite du Comité international de la Croix-Rouge. F, à l'unanimité, respecter l'interdiction d'utiliser contre les civils la famine comme méthode de guerre. 4, par 10 voix contre 1, est d'avis que, en tant que puissance occupante, l'État d'Israël a l'obligation, en vertu du droit international des droits de l'homme, de respecter, de protéger et de réaliser les droits de l'homme de la population du territoire palestinien occupé, y compris par la présence et les activités de l'Organisation des Nations Unies, d'autres organisations internationales et d'États tiers dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge. Contre, Mme Sebutinde, vice-présidente. 5. Par 10 voix contre 1. Est d'avis que l'État d'Israël a l'obligation de coopérer de bonne foi avec l'Organisation des Nations Unies en lui donnant pleine assistance dans toute action entreprise par elle, conformément à la Charte des Nations Unies, y compris par l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge. Contre, Mme Sebutinde, vice-présidente. 6. Par 10 voix contre 1. Est d'avis que l'État d'Israël a l'obligation, en vertu de l'article 105 de la Charte des Nations Unies, d'assurer le plein respect des privilèges et immunités accordés à l'Organisation des Nations Unies, y compris ses organismes et organes et à ses fonctionnaires, dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Brand, Gomez-Robledo, Mme Cleveland, M. Tladi, juge. Contre, Mme Sebutinde, vice-présidente. 7. Par 10 voix contre 1. Est d'avis que l'État d'Israël a l'obligation, en vertu de l'article 2 de la Convention sur les privilèges et immunités des Nations Unies, d'assurer le plein respect de l'inviolabilité des locaux de l'Organisation des Nations Unies, y compris ceux de l'Office de secours et de travaux des Nations Unies pour les réfugiés de Palestine dans le Proche-Orient, et de l'exemption des biens et avoirs de l'organisation de toute forme de contrainte. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge. Contre, Mme Sebutinde, vice-présidente. 8. Par 10 voix contre 1. Est d'avis que l'État d'Israël a l'obligation, en vertu des articles 5, 6 et 7 de la Convention sur les privilèges et immunités des Nations Unies, d'assurer le plein respect des privilèges et immunités accordés aux fonctionnaires de l'Organisation des Nations Unies et aux experts en mission pour l'organisation dans le territoire palestinien occupé et en lien avec celui-ci. Pour M. Iwasawa, président, M. Tomka, Abraham, Mme Choué, M. Nolte, Mme Charlesworth, M. Bran, Gomez-Robledo, Mme Cleveland, M. Tladi, juge. Contre, Mme Sebutinde, vice-présidente.
Vice President Sebutinde appends a separate opinion to the advisory opinion of the court. Judges Abraham and Cleveland appends a joint declaration to the advisory opinion of the court. Judge Chue appends a separate opinion to the advisory opinion of the court. Judge Charlesworth appends a declaration to the advisory opinion of the court. Judge Brandt appends a separate opinion to the advisory opinion of the court. Judge Gomez-Robledo appends a partially dissenting opinion to the advisory opinion of the court. Judges Cleveland and Tladi append declaration to the advisory opinion of the court. The text of the opinion is available from today in TypeScript. It will also be available almost immediately on the court's website. The printed text will be available in the near future. As the court has no other business before it, I declare the sitting closed.
What's that?
you.